Welcome back. We are back after a 10-minute break, and we are in a webinar, role of law in the development of economy. We are gathering professionals of their respective areas, and we are talking about justice system and economy, how it can foster each other. We have the same rules of the game, namely, if you want to ask your questions, and many are asking questions, which we like very much, please send those questions to a number 283-46531. And during the discussion, we will ask those questions to the panelists. Also, the organizers have a special request. Would you be so kind and add to your names an institution that you represent? You can do that by clicking on your name, and then you have a possibility to rename yourself. Please rename yourself, adding an institution that you represent. We would like to understand our audience, and by understanding our audience, we will be able to tell and to organize our conferences better. Now we have the second panel of our discussion, and the name of it is the following: Clear, Understandable, and Just Court Judgment as Grant of Trust by Investors and businessmen. We have panelists, namely Jānis Loze, Chamber of Commerce and Industry of Latvia, then Māris Vainovskis, representing Foreign Investors Council, Valters Ābele, representing Finance Latvia, and Riga Vilson from Riga District Court. And now we will give the floor to the panelists, and after that there will be a Q&A session. I give the floor to Jānis Loze, representing Chamber of Industry and Commerce of Latvia. Good day. Thank you very much for this webinar that you have organized for this very important issue, and for the possibility to our chamber to express a point of view in these issues. I would like to start with the first point of view, namely that for the last 6-7 years, Latvia has made significant progress in justice system. And in Latvia, we have one of the quickest court proceedings in Latvia, with some exceptions. Now it is just several years. In some cases, it's less. It's 1 year, showing that we are on the right path. And in in old European countries, be it in Spain, Italy, or England, these processes are very lengthy, namely for a year or more. And we can be an example. As the aim of this webinar is to express our suggestions as how to foster court proceedings, I would like to turn to our suggestions, namely suggestions of entrepreneurs. What can be done? In company disputes, speed is not always the crucial factor. The quality of judgment is of more important aspect, and I believe that the Ministry of Justice in the coming years will work especially on that. Each judge is as a parliament itself, because the judgment is equal to a law. So I hope that in the future, the court will also explain, not just proclaim, but explain why they take into consideration, why they agree or disagree with some of the evidences, with some of the statements, especially in commercial disputes when there is no appeal process allowed. But because at the moment there are situations that after taking a negative decision, a company submits specific explanations, but at the end, the court just explains a short short sentence that the first instance court or the first judge was correct without any explanations, which doesn't allow our companies to come up with additional explanations because they do not understand or they do not know what is lacking. So this could be made better in the future. Also, we wanted to mention some other options that are already existing and courts could apply already now. For example, even now, judges may close cases when there are certain circumstances. For example, if there is a dispute on applicable law or other reasons. For example, the court looks at the case as to the substance, and parties do have to spend time on preparation of the court, but these issues could be solved at the very beginning. Namely, there could come a court decision that the case is inadmissible. A separate survey could be made and evaluated in how many administrative cases an entrepreneur had a positive decision. Thus, we can eliminate situations that entrepreneurs do have indications that judges and courts will decide against them. Companies, entrepreneurs are friends of country, or are friends of society because they're investing money and energy. And that's why in disputes between entrepreneurs and institutions, both parties should be considered equals. There shouldn't be an right-away decision that the state institution is right and the entrepreneur is wrong. There shouldn't be a presumption that companies are the ones who make mistakes or who are fraudulent. The new council is starting its work already next year. We would be very happy that it could be called commercial court, but whatever the name, we will be able to support. Now we are worried that there are only 2 judges prescribed for this institution and that civil courts will be civil proceedings will be dealt with in this institution. But we hope that that will change, namely that commercial disputes will be the ones that the new institution will deal with as a majority. Our chamber has had very good cooperation with our parliament, with the Ministry of Justice. They always listen to our point of view, and I hope that all issues will be dealt with in a similar manner in the future. Thank you very much, Jānis Loze, representing Chamber of Commerce of Industry of Latvia. And now I give the floor to Māris Vainovskis, representing Foreign Investors Council in Latvia.
Good day. Indeed, my name is Māris Vainovskis of the Foreign Investors Council and chair of the court efficiency working group. I would like to thank the organizers and all of the other institutions represented here today, because this is a very important discussion, but more so than the discussion, it is important what we do in our daily life. And the Foreign Investors Council has been working with the Ministry of Justice for more than 10 years, as well as the Supreme Court, the Constitutional Court, the Prosecutor General's Office, the police. We are trying to give this contribution of expressing the opinions, the needs of the business sector, because the business, regardless of whether it's a foreign investor or a local investor, these are the people that are heating the economy. These are our taxpayers. These are people that are a part of our national economy. So thank you. And in looking back at what we have done, we stopped counting the work hours dedicated to this after hitting 10,000. So I was very touched by what Mr. Neyman said, that all of us on a daily basis have to think about what myself am doing to implement the rule of law. So I would also like to address our dear viewers directly. I assume that there are many people involved in the justice system that are watching this discussion. And I would like to take this opportunity to ask each and every one of you to do something good. And I have a couple of examples that I can give you. There's one condition, that this good deed has to go above and beyond your regular duties. It's something in addition to that. So what could you do? A publication, your next one or your first publication about the about an important judicial matter or matter of case law. Then mentoring. I urge you to examine the possibility of being a mentor for a student of justice. So to give this inspiration to our aspiring lawyers and pass on your knowledge and skills, because the best mentor is one that inspires. What else could you do? For our colleagues, lawyers, work pro bono. Take on a case or perhaps your next case and do it pro bono. And work on this case as if it were the main task, main client that you have, regardless of the fact that it's a pro bono case. So that would be my invitation to you, also in the context of our discussion here today. Do think along, and I would like to challenge you to not only think, but start applying this in practice starting from today. So that's perhaps a little bit of a side note after listening to the first panel discussion. As for the requirements and needs of the business sector, a lot has already been contained in the title of our discussion. So regardless of whether it's a foreign business or a local business, the decision to invest is to a great extent based on the efficiency of the justice system and its ability to resolve various disputes. Because for any entrepreneur, their dispute is the main dispute, their most important issue to resolve at any given point in time. And this all goes back to trust in the system. The minister already mentioned an example or that at a court sitting, a judge has said that they're just looking at facts and the law, and that fairness is something to be sought elsewhere. Dear colleagues, that is truly a fundamentally incorrect premise. As what Mr. Bukovsky said, one of our leading justice experts, and I hope to quote him precisely. He said that the courts have the high but very difficult responsibility to ensure fairness within the framework of law and rights. So the courts have to ensure fairness. So what is fairness? It is an understanding. It is where the situation where people see decisions as fair, therefore they see courts as an authority. If a prerequisite for fairness is understanding. So even the, so to say, losing party, if they understand the decision, then they will see it as a fair one. And then we don't have needless appeals. The court system is not burdened where it does not have to be burdened. So it is a complex of various principles that are applied. And as for practical steps, I have perhaps a couple of proposals on the part of the Foreign Investors Council. I am a practicing lawyer and I work with many clients. One of the main things in my work is managing expectations. If a client comes to me or writes to me, what's going on with my case? So have I done my job well? If my client doesn't know what's going on in their case, if we look at the justice system as a whole, each party involved in the system has this expectation. They want to see the court that is ready for dealing with their case. They want to understand what is going to happen. They want to see a welcoming attitude. They want to see that the involved parties have prepared. We've had many discussions about these preparatory meetings. This is a tool that is underused. So managing expectations, preparing, this is something that promotes trust in the justice system and also satisfaction with the result, this regardless of whether you are on the winning or losing side. Another thing I'd like to mention is the professionalism. I'd like to thank the Ministry of Justice for working on the establishing the economic case court. And these are necessary improvements, but of course a lot will depend on the actual daily work that will be done, not only in this economic court, but in any court institution. The Prosecutor General's office has also had a good proposal for reforms to establish a specialized tax and customs prosecutor's office under the State Revenue Service. And this is a specialization, this is competence aimed at improving efficiency. In conclusion, I think that the main thing here is the attitude passed down from the top management. So overall, the business sector has feels that things are going in the right direction. But it is very important to continue discussion to remunerate the good efforts and maintain this positive approach from the Prosecutor General, from the Ministry of Justice, and also to continue this discussion in general. And I think today's panel discussion is a contribution to this. So thank you, and do recall the challenge I presented to you to start doing good deeds today in order to improve the justice system, because the state, that is us ourselves, we are the ones that improve or don't improve our daily life. Thank you, Mr. Vanovskis. from the Foreign Investors Council in Latvia for your inspirational address. And to a certain extent, you were actually a mentor to us all here. So thank you for that. Now I give the floor to Valters Ābele from Finance Latvia.
Thank you for your invitation. It is difficult to talk about such an inspirational speech, but I would like to tell about some economic aspects. Very many lawyers have been speaking, and I am a risk director in the bank Citadele, so that's why I will talk from the economic perspective, how courts and court processes impact creditors. We are more talking about creditors, bank creditors and out-of-bank creditors. We have to start with facts. First of all, finance and capital flows go hand in hand with growth of a country, of national economy. It is a very important component of the growth. The more credits and loans there is in the country, the bigger growth through investments, through economic growth, direct and indirect. And these flows are global. And COVID is not changing anything and will not change anything. Those flows will stay global. And that's why it is important for our country to be sustainable and to be able to show to investors, creditors, to of us, of the country, of area, of a company, that there are possibilities to turn to courts if something goes wrong. There is such a thing in economy, that sometimes something goes wrong, be it a problem of a company because of a bad business strategy, or be it of an area or a country. The investors are interested in recovery processes, whether they are clear and whether they are based on swift judgments. That is one thing. And another factor from my daily life, we in bank perform collecting of assets for uncertain credits. All creditors are involved in this process, and you might not like these budget lines, but there is a line, a notion, savings for against bad credits. And this is the line that differs budgets of companies, of banks, year by year. Why I'm talking about that? Credits through recoveries are the ones who courts are dealing with. And that's why it is very important to understand that there is a close correlation without financial flows and court systems. I want today to talk not about so much justice, but I understand it's very, very important, but about timeliness of court proceedings. The biggest improvements could be done in by improving this timeliness. What I mean by timeliness, when we speak about recovery, most probably this money is frozen. It is not used for other credits. It doesn't flow into the economy. Of course, there are some expenses, court fees and money to be paid to lawyers. But every litigation year, we spend about 5% of all banks' assets. It is a frozen money as well as a direct fees involved in litigation. If we are speaking about bigger sums or bigger cases of litigation, this sum could be lower. But that goes hand in hand what we heard from commerce and industry. chamber, there we can observe already a progress in civil cases when we speak about 4 or 5 months, which is good. And this is timely. And no one is expecting anything faster. But there are some cases and some aspects when parties or because of another party, the processes are getting lengthier. And in these cases, I would like to come up with 2 specific suggestions or requests for evaluation for courts, namely postponing of sittings. In some courts, it is very common practice, and we believe that it is an obvious cause, an obvious angle, an obvious factor in impacting the length of court proceedings. Sometimes the judges should consider holding a sitting without presence of a party if there is a representative, for example. Also, second suggestion, we are not criticizing, we are not criticizing you, but in some courts, there is a principle that the court is going to agree to a request and not to explain refusal. I understand that for explanation of refusal, more work is required, but that shouldn't be considered as such. And as a solution, we propose the following, especially in the circumstances of COVID, written proceedings, which will allow the legislators to raise these thresholds and to raise also the image of courts. And the last suggestion, which will be more discussed during the next panel, are criminal cases where there are a lot of things to be done. And now those criminal cases are very lengthy. Maybe that is the reason why we have so few cases submitted about fraudulent actions within insolvency processes, within other cases dealing with financial matters. But I will leave it for the next panel. Thank you, Mr. Abele from Finance Latvia. And now I give the floor to Daiga Vilsone from Riga District Court.
Thank you for giving me the floor. Good day to our listeners. So in preparing for any conference, you always want to speak about certain issues and place your emphasis on certain aspects. But being at the conference and listening to the other speakers, I often find myself coming to the conclusion that I have to add something onto my speech and focus on some other aspects. So for that reason, today I would like to divide my speech into 2 main blocks. The first will be an invitation, address to entrepreneurs and foreign investors who are obviously interested in efficient court processes. And the other block will be my explanation of what the improvements that I see we could make to improve the efficiency of the work of the courts, because without an efficient court process, we cannot achieve a clear, understandable, and fair decision. Therefore, let me get to it. I would like to highlight that Latvia has a 3-level court system, but in a proper court proceedings begins from the very first level. So dear entrepreneurs, dear representatives, I urge you to use the first instance courts as a proper court process. We should stop or try to stop using this practice where first instance courts are sort of a tryout, and that the real court proceedings start only at appeals or the second instance. The second instance or appeals court cannot be the actual goal. Therefore, it is important to use your rights honestly and to fulfill your obligations honestly. This means that as much as possible, provide all proof you have to the first instance court so that this first instance court can have a proper view of the actual situation of the case. And what we expect from professional judges, from not you as the customers, clients of the court, but us as the justice system as a whole, means that the judge will bring to your attention if there is a fact that is disputed in court, but there is no proof submitted to show your opinion of this fact. So how we can improve the regulations existing and how to improve the efficiency of court process is to provide instruction as to what the judge has to do. Yes, we have the principle of competition, but in order to achieve a proper result, I completely agree with Mr. Loza that to wait for the court to say that the case has, the validity of the case has ended is not a proper practice. We don't have to necessarily have to go through first and second and appeals courts. These are resources and time that is wasted for both the courts and the clients. Another aspect that I'd like to draw your attention to is, in my opinion, if we have a quality and efficient process at the first instance, then the appeals process should be done in writing. And here we can draw inspiration from our foreign colleagues who apply such an appeals process as a general norm, and only in exceptional cases, if the court sees it necessary, is the case examined in an oral process in appeals court. We can provide in the law that the appeals instance, that a party to the case can request an oral process, but the format of the process would be at the discretion of the court, because the court can decide whether an oral process is needed. If there is no need to interview witnesses to verify specific facts, which can actually also be done through writing, then the oral procedure most definitely takes up your time, and it takes up not only the state resources, but also the time and financial resources of the client of the court. I'd like to draw your attention to the fact that the written procedure is also possible in criminal proceedings, especially in appeals court. And here again, we can take inspiration from our neighbor Estonia, where this procedure and the parties to the case in this procedure do not have veto rights. As you know, we currently have an exceptional regulation in place based on the COVID pandemic, where the courts have been given the opportunity to work in writing. This should actually be included in our legislation as a permanent right of the courts in order to improve the efficiency of the whole process. Another aspect that I'd like to highlight, we are living in the era of a digital revolution, and this pandemic has also shown us that it is possible to work remotely. Of course, we can't do absolutely everything remotely, but we can do a lot. And what is important for both the courts as well as the clients of the court, we are working remotely, we have to comply with security or with precautions and to ensure that the court, as the holder of the state authority, has to protect personal data. And why do I mention this? Because nowadays we have so many platforms that we can use. We have Zoom and MS Teams. We can use various platforms for remote working, but the work of courts can only be performed in a secure environment. The court's administration is currently working on developing such a platform where the data is stored and is not accessible to unauthorized parties. And we see that this could be one of the most effective models to use, also perhaps for the newly established economic court, especially in terms of civil cases. This would definitely save your time. This would be a very good model for representatives, for lawyers. If you would like to attend the proceedings or participate in the proceedings yourself, you can do this remotely. I think this would be an excellent opportunity. And we can also, in this respect, look at what has already been done in Latvia. For notaries, we have a DigiNotary system developed, which provides the secure environment and authorization of parties, verification of identity. So all of this is doable. Another thing that was mentioned by my colleagues here today regarding the volume of decisions or the time necessary to produce a decision. I do agree that we tend to have very lengthy court decisions, but it is always related to the actual amount of information in the case. This would be I would like to address the judges as well as lawyers and clients. If we all pay attention to expressing ourselves concisely and only speaking about relevant matters, then we won't have such lengthy cases. Obviously, this need to just write as much as possible is not a preferable characteristic for any party involved in court proceedings. As regards delaying court sittings, here we have two aspects. To a great extent, the delaying of sittings is related to objective reasons. And here we have to consider the fact that the court is obliged to explain to the parties if there is a dispute over any proof submitted. But I also agree that this is an issue that has to be dealt with as much as possible during preparatory sittings. And in conclusion, I'd like to mention one more important aspect: a clear, understandable, and fair decision. I can say with certainty that court decisions can say anything, but if we don't trust the court, we will never see this decision as fair. So trust in courts is of paramount importance, and trust in the justice system as a whole. And here we all have to work together. The justice system itself, we cannot have institutional disputes between ourselves saying that courts of lower instance are doing low quality work if we don't give specific facts, or if we give just a single fact and then generalize it to the whole court. Because the question always stands, what have we done ourselves to promote dialogue between courts, to promote more professional, more effective, efficient work of the courts? This applies to the court system itself, because these arrogant statements about other colleagues will never promote trust in the justice system as a whole. That same applies to the legislature, to the executive power. Courts cannot self-defend themselves. This is not the case in any countries. We have to want a strong state, a strong justice system. How can we convince society that we have a quality, strong justice system? This has to be done by those involved in the system to use all of the opportunities they have to explain the work of the courts, talk about the work of the courts in the public space. And instead of placing a highlight on the public relations involved in court proceedings, which of course is sometimes important if there is a problem issue to be addressed, because healthy, constructive criticism is very much needed. We try to identify problems ourselves, we do identify them, and then it is no longer a problem, it is an assignment to a task to resolve. We have to find the best solution for it. Therefore, I'd like to say that each and every one of us is responsible for whether we trust the justice system, whether we trust Latvia being a country governed by the rule of law, and whether we will truly trust that Latvian courts can provide understandable, clear, and fair decisions. Thank you, ladies and gentlemen.
Thank you, Daiga Wilson, representing Riga District Court. We have received numerous questions to the participants, and the participants also gave very, very good speeches, full of facts. They gave us so many questions that we could discuss, that we could stay here forever, but one or one question was the following. Each and every one of you, very briefly, many mentioned things that could be made better. So do tell about one thing that could be solved easily and rapidly. According to your perspective, what could be solved in the system easily? And most probably it's not being done because there is a routine or something not allowing to do that. According to you, what could be made better, like tomorrow, if everyone agreed to that? I understand. I don't remember, but I know from the first times of the Republic, in a very difficult case of sharing common property, sharing out common property, a judge took both parties, went to the property, and saw right there on the spot where was the problem. But that was question of authority of the judge, because there on spot, everything was so clear and it could be solved. Maybe that is not exactly an answer to your question, but you, I hope, understood my example. Thank you, Maris. Very shortly, I wish judges to be more courageous, because now I think that especially the first instance courts are kind of afraid or cautious that the second instance or appeal judges are afraid of what their colleagues are going to think about. So I wish all the judges, especially first instance judges, to be courageous and have their sense of authority. Me, from the economic side, I will answer the question. I believe that a justice system is a big system with resources, with underwater sharp rocks, so it won't be easy to solve anything tomorrow. But I believe that the changes could be made in an evolutional way, not revolutionary way. Some things have already been suggested, but I would like to say that the question of support from the society, internal trust and trust of judges are the first steps. From my side, I would like to say that it would be easy enough starting from tomorrow to use preparatory court sittings. But again, here, according to our conventional law, the first instance courts are not very keen on using this opportunity of preparatory sittings. But it cannot be done revolutionary, as a colleague said, but evolutionary. We have to persuade them. When district court was the first instance court, we used these preparatory meetings in cases where we saw necessity for it. We have 2 or 3 questions regarding the same. I'm asking mainly the following. Maybe there could be mechanisms in place helping to solve a case before, out of court. Yes, first of all, precedents of case law, we hope, or when we will be able to see that all courts or all levels of court decide the same, or in a very prescribed way, then parties will choose not to go to court. Here, we could develop, and either by legislation to solve or by establishing such a practice, so-called pilot cases. If there are several cases with a similar factual basis, it should be of utmost importance that one of those cases could be solved quickly in order for other courts or cases to be based on precedent, on case law. We tried to solve it in a way of a dialogue, but we were not satisfied ourselves. So most probably we need a new piece of legislation to regulate that. Speaking from the point of view of creditors, if we speak about banks, there are many situations where credit restructurization solutions are being offered. Very important it is to come to banks and to look for solutions out of court. And also mediation institution as support to court system, not as something aside, in parallel, but something within justice system. And that will help us, help overall image of the court. Thank you very much for your speeches in an informative level, also in all other kinds of levels. And I wish all of you, and especially the judges, to have courage and to have this common sense and feeling of justice and stand for it and be courageous. So we will resume in 10 minutes. You can follow this clock on your screens, and we will resume in 10 minutes after a technical break. Thank you.